Abortion is legal throughout the United States and its territories. Although restrictions and accessibility vary from state to state, abortion is a controversial and divisive issue in the society, culture and politics of the U.S., and various anti-abortion laws have been in force in each state since at least 1900. Since 1976, the Republican Party has generally sought to restrict abortion access or criminalize abortion, whereas the Democratic Party has generally defended access to abortion and has made contraception easier to obtain. Before the Supreme Court of the United States decisions of Roe v. Wade and Doe v. Bolton decriminalized abortion nationwide in 1973, abortion was already legal in several states, but the decision in the former case imposed a uniform framework for state legislation on the subject. It established a minimal period during which abortion is legal. That basic framework, modified in Planned Parenthood v. Casey, remains nominally in place, although the effective availability of abortion varies significantly from state to state, as many counties have no abortion providers. Planned Parenthood v. Casey held that a law cannot place legal restrictions imposing an undue burden for the purpose or effect of placing a substantial obstacle in the path of a woman seeking an abortion of a non-viable fetus. The abortion rate has continuously fallen from a peak in 1980 of 30 per 1,000 women of childbearing age, to 11.3 abortions per 1,000 women by 2018. In 2018, 77.7% of abortions were performed at 9 weeks or less gestation, and 92.2% of abortions were performed at 13 weeks or less gestation. Increased access to birth control has been statistically linked to reductions in the abortion rate. The main actors in the abortion debate are often framed as pro-choice, believing that a woman is entitled to choose whether to continue her pregnancy, versus pro-life, believing that the fetus has a right to live, though most Americans are found to agree with some positions of each side. A 2018 Gallup survey found the percentages of pro-choice, or pro-life, respondents were equal. The poll results also indicated that Americans harbor diverse and shifting opinions on the legal right to abortion. The survey found that 29% of respondents believed that abortion should be legal in all circumstances, 50% that it should be legal under some circumstances, and 20% that it should be illegal in all circumstances. As of 2007, polling results found that 34% of Americans were satisfied with abortion laws. The abortion debate most commonly relates to the induced abortion of an embryo or fetus at some point in a pregnancy, which is also how the term is used in a legal sense. Some also use the term elective abortion, which is used in relation to a claim to an unrestricted right of a woman to an abortion, whether or not she chooses to have one. The term elective abortion or voluntary abortion describes the interruption of pregnancy before viability at the request of the woman, but not for medical reasons. In medical parlance, abortion can refer to either miscarriage or abortion until the fetus is viable. After viability, doctors call an abortion a termination of pregnancy. When the United States first became independent, most states applied English common law to abortion. This meant it was not permitted after quickening, or the start of fetal movements, usually felt 15 to 20 weeks after conception. Abortion has existed in America since European colonization. The earliest settlers would often encourage abortions before the quickening stage in the pregnancy. There were many reasons given for this, including not having resources to bear children. By the late 1800s, states began to make abortions illegal. One reason given for the legislation was that abortions had been performed with dangerous methods and were often surgical. Because of this, many states decided to forbid abortions. As technology advanced and abortion methods improved, abortion still remained illegal. Women would resort to illegal, unsafe methods, also known as back alley abortions. Abortions became illegal by statute in Britain in 1803 with Lord Ellenborough's Act. Various anti-abortion statutes that codified our expanded common law began to appear in the United States in the 1820s. Some historians argue a Connecticut law targeted apothecaries who sold poisons to women for purposes of inducing an abortion. However, additional research into the Connecticut law reveals the state legislation enacted the law based on the case of the state of Connecticut vs. Ummi Rogers. New York made post-quickening abortions a felony and pre-quickening abortions a misdemeanor in 1829. Other legal scholars have pointed out that some of the early laws punished not only the doctor or abortionist, but also the woman who hired them. A number of other factors likely played a role in the rise of anti-abortion laws. Physicians, who were the leading advocates of abortion,